Hey, everybody, welcome back. We're live tonight on YouTube. Welcome to Advocates of Justice Foreclosure Defense Paralegal Service. And we are different and we prove it. And we do more than just that. So we help people clean up repair your credit, third party debt. Yep. We do it all. So welcome tonight. I'm going to give myself a thumbs up because I'm pretty sure I'm going to be happy about what we talk about tonight. And so let's just get right to it. What are we going to talk about tonight? Well, first off, we're going to give another update. I had a YouTube subscriber message me or send me a message on YouTube letting me know that she had used the concepts and got the court to the magistrate judge to dismiss the attorney's foreclosure action. Dismiss with prejudice, she said. That's huge because usually the attorney just walk away. That's usually what happens. Usually it doesn't get dismissed with prejudice, but that's what happened in her case. And she was new. Her comment to me was, should she go after the magistrate judge because he didn't have jurisdiction to dismiss it? I'm like, no, I think you're good. If you got it dismissed, that's what we're after. We don't want to stir up anymore. If the judge don't have jurisdiction, that's what they're supposed to do. They're supposed to dismiss it. We don't know that because it ain't happened very often, but we starting to get it. We starting to get it done now. So that's pretty cool. So tonight we're going to talk about obstacles and some fear. So obstacles is going to be the first thing on our list. The biggest obstacles that's blocking you from taking control of your foreclosure or just taking action. Some of these obstacles are blocking people from taking action and they wait. I'm guessing for the knock to come on the door when it's time to throw your stuff in the yard. I don't know, but we're going to talk about that. And then you can decide how many of these obstacles or excuses are interfering with your ability to take control of your situation. We're also going to talk about some of the biggest mistakes that homeowners make. The biggest mistakes that homeowners make in foreclosure defense. And we're going to see how many of those mistakes that you're making or made if you're already in the program. We're going to give some of you a break that's in the program already because you're not making any mistakes no more. And third, last but not least, we're going to talk about the end of the moratorium sale that we're having right now. Not a good time to not be able to talk while you're streaming live, but we'll make it through this. Let's get started. So I want you to think about what are some of the biggest obstacles that are blocking you from control. I think one of the main obstacles that's blocking people from taking control and having control is believing the lies the attorneys have indoctrinated the public to believe for like 160 years or something, maybe more. Those lies are blocking people from stepping forward, and we're going to go over a couple of those lies. Also, one of the main ones I get from people all the time is the fear of looking stupid. They're scared to go to court because they're scared they're going to look stupid. They're going to say something stupid. They're going to laugh at you. Newsflash, they're already laughing at your ass. I'm telling you, they are already laughing at you because they're taking your shit and you have not done anything. You can't figure it out. They're already laughing. So people who are worried about them laughing at you in court, you know what? You go into court and kick their ass all over the courtroom. They're still going to laugh. They're still going to play it off like you ain't got shit. And that's what we're trying to teach you guys how to do too when they're picking at your paperwork. We'll talk about that in a different video. But that's what we need to teach you guys how to do. Play it off. Yep. And here are a few others. This is one, a huge one. This is a lie that people believe. Attorneys have a license to practice law. Nope. They don't have no license to practice law. Sure don't. And that is one of the biggest lies that they tell people. And how does that lie affect you? Well, they're giving you a hard time all day long, making you jump through all these hoops with your documents to make them sure that they're, yeah, and attorneys don't even have a license. I'm going to show you guys. I'm going to show you guys one of my. I'm going to show you one of my research pages that I use with my notes on it, and just let you take a look at how much attorneys don't have a don't have a license. And this is what I use when they get in my face. When they try to get in my face and give me crap, that's the first thing I tell attorneys, dude. You think I'm engaged in the unauthorized practice of law without a license? Maybe you could text me a picture of your license. I'd like to see a copy of a license to practice law. Because according to according to according to Swear versus the Board of Examiners, no state, and if you notice, they say the practice of law cannot be licensed by any state, lower and uppercase. Square versus Board of Examiners. So if there's no license, what is that they're holding all the time, trying to stick in people's face? Oh, that's their bar card. Oh, well, let's roll down here. The practice of law is occupation of common right. Sims versus Ahrens. The certificate from the state Supreme Court only authorizes to practice law in courts as a member of the judicial branch of government and can only represent wards of the court, infants, persons of unsound mind, incompetent people. That's who attorneys represent. And here it is right here. The certificate is not a license to practice law, nor do business as a law firm. The state bar card is not a license. It's a union dues card. Yeah. So I think I've made the point here pretty much, right? And I'm going to copy and paste some of these case laws in the comment section under this live stream when it's all said and done. So if you guys ever need to use any of these in your paperwork, you can find it in the comment section. And as you can see, oh, this is a good one. The state bar is unconstitutional monopoly and an illegal enterprise. Violates Article 2, Section 1, the separation clause in the Constitution. Yeah, so that pretty much wraps it up. And I have several pages of that I like to throw in their face when they want to try and be stupid. So let's get on to the next one. And this next one is kind of interesting. So most people don't want to fight because you have no chance to win in the court. And I'm going to have to say this one is kind of right because of the corruption and fraud. You have no chance to win. To win is to get the judge to say, oh, right, you're right, and dismiss the case. Now, with that said, we just got a couple of wins last week and the week before last and last month. So that might have to change. But to make the point here, the point is that the judge is a bar member, the attorney's a bar member, the clerk's a bar member, everybody working in the clerk's office that's avoiding filing your shit, they're all bar members. So the judge is not going to say, okay, you win, here you go. Now, we have had the judge go sit down because we had to sue the judge as soon as the judge started helping the attorneys, and that's how we got that. So we're learning how to cut to the chase. But to make this point, You can't depend on the judge to be fair and give you the win when you know you deserve it. So what we do is we want to make them give up. We want to make them tap out. For you people to understand, tap out is when you hit that floor a couple of times because you're about to get choked out or getting stomped in the face and you can't defend yourself. We want to make them tap out. When they tap out, you don't have to worry about this stupid appeal, none of that stuff. When they tap out, they go sit their happy asses down. And that's what we're looking for. Now, here's another one, another lie that attorneys have made us believe, that you must hire an attorney because you can't do it yourself. You need to hire an attorney. How many times have they told you that? Even when you go into the court, the clerks will tell you, oh, you need to hire an attorney. Oh, you can't file that because you have the attorney as an everyone defendant. So the attorney, no, you can't file that. No, you can't. But as soon as you ask the question, oh, well, we can't give you legal advice. Wait a minute, you was just giving me some damn legal advice over there, advice that was going to help kick my ass. But when I ask you for some real shit, all of a sudden, yeah, all right. So whenever the clerk starts telling you what you need to do, you need to ask them, what are you giving me legal advice? Because my legal team told me that you're not allowed to give me legal advice. You're only allowed to let me know what the procedure is for getting the administrative procedure for getting the paperwork right or whatever, so the court don't have issues. The kind of issues that the court has when they take a foreclosure lawsuit, but there's no injured party. Yeah, those kind of issues are the ones that you guys are supposed to prevent. But it appears that they only get prevented on one side and not on my side. Yeah, you know what I'm saying? Now, here's one that most people have no idea. Okay, this is a big lie, that you're in a judicial court proceedings. Everybody thinks they're in a judicial court proceedings. Okay, you're not in a judicial court proceedings. You're in administrative court proceedings. And if you don't know the difference, you're going to get hosed. If you don't have a game plan, you're going to get hosed. And if you think I'm not, here's the deal. In judicial proceedings, it would be under the common law, and there would need to be a damn injured party. I'm just saying, there need to be an injured party. If there's no injured party, and you're going by these statutes and rules that they put together that they keep changing all the time, then you're in an administrative process. Yep. And we know how to get around that because as soon as the judge starts getting out of control, you sue the judge and hold them accountable. We learn how to cut to the chase. Yep. Now, here's one that most people have no idea too. This is most people, that you have constitutional rights in court. You don't have any constitutional rights in court. You have no rights anywhere. Even if you're white, I don't care. It don't matter what color you are. You have no rights in foreclosure court. You have no constitutional rights. And the reason why you don't have any rights is because you're not in a judicial court. You're in an administrative court under statutes and codes and ordinances and all this shit that they made up that are not valid laws. So if you're in their fake court, then you have no constitutional rights unless you jam them up to force them to do the right thing. And that's what we learn how to do. You have no constitutional rights. You're not in a court that has constitutional rights. You're in an administrative court being screwed over is what you are. Oh, here's one. The judge is going to be fair. I hear people telling me all the time, well, I'm going into the eviction court and I'm just going to explain to the judge. No, you have no idea. Okay. The judge is getting a piece of the pie. All the attorneys are getting a piece of the action. When you hire an attorney to help you, that attorney automatically gets a piece of the action and throw your ass under the bus, and they get to take whatever they can take out of your bank account while they make you think they're helping you while they're throwing your ass under the bus. So anybody that thinks that I don't know about this or I got this wrong, boy, you just leave a message in the comment section and let me know. And I also want to offer, offer to anybody out there that wants to challenge me, or any of you attorneys out there that think that I don't know what the hell I'm talking about, you let me know when you can come on, and we'll have a show just for you, and we'll do a Zoom. We'll do a live Zoom, and we'll talk. I'll talk. You talk. We'll work it out. I'll be nice to you. I want to hear what you have to say to everybody, because I've done my homework. And the judge is not going to be fair in court. So I'm not even going to spend much time on that, because everybody already finding that out. Now, here's one that most people don't have no idea. Most people think the judge has the last say. Not in our program. Judge don't get the last say in our program, okay? Because what the judge gets the last say in our program, the last say the judge gets to say in our program is, see you later. When we get done recusing the judge and filing a notice of claim and actually filing a lawsuit against the judge is not getting the last say. And people get this twisted a lot. The judge will tell you, well, I don't care if you don't agree with my ruling, file your appeal. The hell with an appeal. Why are you going to waste your time filing an appeal when a judge screws you over? Why don't you just sue him? Cut to the chase. Just sue him. That's what we do. When a judge violates you, he's violating the law, he's violating the Constitution, he's violating your rights, violating all of that shit to help the attorneys. Who got time to do a stinking appeal? People need to remember that the program they structured for them. It's not for us. So while you're busy doing your appeal, you're running out your time to do anything about a situation, because nobody's going to help you in appellate court. I haven't seen that happen for very many people in foreclosure or in anything. There's a few people that come out of there looking good, but you know what? Now you come out of the appellate court, you win your appeal, yay! And you go back to the stinking court where the judge was throwing your ass under the bus, and you got to start shit all over again. So that's why we just like to sue their ass and be done with it. Yep. And once you file your lawsuit against the judge, and this is what we found out in the case that we won here, that I've been posting the updates to, what we found out is once you file your shit, you bring the heat that I got up in the judge's face. I don't just think about it. If you were the other judges, would you stick your hand out there and tag on that? No, they don't want nothing to do with it. And that's the beauty of the strategy that we use. You jam up the judge, the rest of the judges don't want that. Who wants to get in the middle of that? It's stinky over there. Yeah. So when the judge violates you, file an appeal, that's not an option for me. And if you are in my group and file an appeal, you're going to get sent to the bench. We don't have time for that. You just need to sue the judge. And people need to realize that you can recuse a judge easy. All you have to do is show the appearance of impartiality. You don't have to prove anything or do all of that. You just have to show the appearance of impartiality. And basically what you learn how to do in our program is you learn, and it's kind of been difficult for me to be able to put this in words, because I've been doing this for so long. It's hard for me to explain it to people. But basically what you're doing in my program is you're building your record you're building your court record of the judge violating the jurisdiction, and that you're addressing the violation of the jurisdiction and jamming up the court for the court's jurisdiction to proceed. And eventually the judge is going to proceed without proving jurisdiction because they don't have it. And when that happens, now you can sue the judge. And that whole court record of all those 28 documents that you've been filing, sticking up in their face, yep, that's your evidence. That is your evidence that the judge violated you by taking jurisdiction without legal authority. That evidence, all of those things that you filed, is your evidence that you're going to use in your lawsuit to prove that the judge violated you. So now you're dragging their asses to the table to come talk about what you want to talk about, them violating your ass in state court, violating your constitutional rights, violating the law. You want to talk, we're going to be talking about all of that instead of the banking stuff. That's a better picture. And what we're seeing now is the judges are just, well, we've had 2 or 3 that just dismissed it. One was dismissed with prejudice, which was priceless because we don't see that, but we're starting to. And that means that we're starting to step up and figure some shit out. Now, one of the things I want to talk about is the biggest mistakes that most people make. The biggest mistake that most people make. Before we get started on that, I want to double check and see who all's here. Hey, everybody. So, Miss J-Ski, what's message me your name, Miss Jetski, Miss J-Ski. I wonder. I don't remember when you signed up in the program. You're the one that you're the one that sent me the notice letting me know that the judge dismissed your stuff with prejudice. That was priceless. You did a great job. How long after the case is closed can you sue the Tina, you're new. We don't wait till no case is closed. You don't have to wait till nothing is closed. And that's what we're learning how to do. Cut to the chase. As a matter of fact, the new state package that I'm putting together, that's going to have the lawsuit that we used to get the win that we got where the judge actually dismissed it. We're going to serve that as a notice of claim right at the beginning of the case in the new package. You know, we're going to serve them right as a notice of claim at the beginning of the case, because my whole thing is to make them go sit the hell down and leave you alone. We ain't trying to go to court, okay? Because I already know how that goes when you have to go to court. So we ain't trying to have to do that. So no, there's no wait till after the case is closed to sue the judge. You want to sue the judge as soon as the judge violates your rights to give the attorneys a free shot. That's when you sue the judge. That's when you turn everything away from the foreclosure over to them violating your rights, and you make a big ass deal about it, and you file our document that I put together for $75. Yeah, the lawsuit. Now, I'm putting together a package that's going to have the blueprint of what I used minus what we didn't need. But the lawsuit that I filed to get this win is on sale right now for $75. And I'm going to paste a link to it in the group. And once I get the state package done, that lawsuit is going to be part of the state package. The $75 deal will not be on the table any longer. So, and I don't want to hear nobody crying about it, okay? Because you have 3 or 4 weeks to come up with the $75. So here we go. This is pretty badass. So Tina, your case is only closed when you go sit the hell down. Okay. No case is closed because you can challenge jurisdiction at any time up to 15 years. So no case is closed. They try to tell you that shit. It's ridiculous. Okay. No case is closed. And I have that right in the jurisdictional challenge with an affidavit. That document you'll get free along with the magistrate's reconsideration package when you invest in either one of my lawsuit packages, which are marked down right now. Having a moratorium into the moratorium sale, and my lawsuit packages have been marked down to a very low price. I got it marked down to $299. Well, one's $299 and one's still at $300. So I forgot to mark it down to $299. So I'm going to post these links in the group too for you guys, because you know these packages, when I started putting them together 2 years ago, they were $1,700, and then I went down to $850, and then the coronavirus started. So I went down further because I knew people were going to be broke. And the whole goal behind doing this was to help people kick attorneys' asses. So I've had to lower the price down to what people could afford. And frankly, if a third of the people that need this pay the $75 for it, I won't be missing any meals. So I'm good with making it cheap because that's what I'm here for. So Tina said, good, because she's not sitting down. So when I first put this package for $75 out there, I told people, well, this is going to be kind of complicated because what I did, I used the package for, and I built up this whole list of like I'm teaching you guys how to do that they couldn't respond to or whatever. But you know what? At the end of the day, the judge that made it for you, Tina, and anybody else in your situation, at the end of the day, the judge made a decision without an injured party. Okay, without an injured party. There's no injured party to give the court jurisdiction. Okay, and the statute that they use for the foreclosure is not a valid law. It does not contain the three elements necessary to be considered a valid law. So each state constitution, and I talked about this in a couple of my videos, each state constitution mandates that for something to be a valid law, it has to have an enacting clause, which tells everybody from what authority the law came from, who's subject to following it. You have to have a title and a body. And statutes and codes, ordinances, policies, none of that shit has the three elements necessary to be a valid law. So in judicial and non-judicial foreclosure, the foreclosure is done by using a statute, which is not a valid law. That alone could be grounds to move to have all the shit stuff shoved in the attorney's face, in the attorney's faces. Let me go ahead and post the other one here, package that's on sale, so I don't forget. So the first one was non-judicial, and this is the judicial package. So A says, what about when you bought the house fully paid cash 2 years later and get a mail from the city saying that the house would be sold after such an amount was owed and paid? Well, so Ace, so here's the deal with that. I have people in our private Facebook page who are facing foreclosure, and they have all the documentation to prove that the loan was paid off. They had the deed, the lien release, all that paperwork. So what happened? So what happened was that when they tricked you into registering your deed in their office, the deed to your property in their office, that allowed their other slime bag parasites to come in and get your information. So they get your property information, and then they go back to the office and they make a fake assignment, and then they file that assignment against your property and make it look like the lender gave it to them and all of this stuff, when in fact the lender don't have shit to do with anything, and they're just scheming fraud to take your property is what they're doing. So there's no what about it. I don't know what you're asking me. You file a lawsuit in their face and sue their asses. There's no more to talk about. So I have a couple of other offers also that I want to share with you guys. So the new offer that I just put together, and it's on the sale as well. And this offer, so I had some people that contacted me about sidewalk repairs. Apparently, some cities have a sidewalk improvement program where they're forcing you to pay $12, $14, $15,000 for sidewalk repairs. And not only do you have to pay for the repairs, you have to pay the repair. You have to use the city's contractors. What kind of shit is that? So we put this notice of claim letter together, to jam up the city because the city cannot make you pay for sidewalk repairs. The sidewalk was actually structured when they built the street. So I don't know how they figure in the homeowner is responsible for paying for the sidewalk repairs. But and the interesting thing about this notice of claim letter is it's similar to the lawsuit, and it's set up for sidewalk repairs right now, but this can be changed and used for anything the city's coming after you for, trying to make you pay for that you don't agree with, pretty much. Think about it. The city giving you shit because you didn't mow your yard, they sent you a ticket. Yep. Or maybe you have a short-term rental and the city's trying to shut you down, or you have Airbnb that you're running and the city's trying to shut you down because you're not paying all their fees and all the extra crap. That they don't have a right to come after you for any of that stuff. And having your deed in their office is what gives them the fake right they think they have to screw with you. So this letter puts them on notice that you're going to file a lawsuit against them if they keep screwing with you with these petty ass fees that they're charging. This letter is only $75. So I had a lady that contacted me, and which was one of the reasons why I put this together. And they're trying to get $1,200 out of her. And if she refuses to pay, then what they're going to do is they're going to add that payment to her property tax bill. And if she don't pay the property tax bill, then some parasite property tax person is going to come in and buy it, and then they're going to try and foreclose on you and kick you off of the property for a bill to repair the damn sidewalk. Yeah, that's what they're setting people up for. Anybody that think I don't understand this or I don't have this right, you guys let me know, because I'm right up on the front getting real-time feedback from 597 people in our private Facebook page and some other folks too that are not in the page that find me. And this is what the feedback is telling us. So let's get back so I can finish up what we were talking about real quick. So some of the biggest mistakes that people make, and when I look at this list, I keep wanting to redo it and shuffle them all around. But I'm not sure I can have like the biggest one because they're all, but let's just get started. Some of the biggest mistakes. One of the biggest mistakes people make is thinking that they made you a real loan. Yeah, that's a problem. Because if you think they made you a real loan, then you're going to have a real hard time understanding the shit that I'm teaching you how to do, because they didn't make you no damn loan. What they did was they after you signed and left the table, okay, they stamped pay to an order of on that promissory note, and they turned it into a security. It's like a check, but when it's a high amount of money like that, they call it a security. They turned it into a security, and they processed that security to the Federal Reserve for electronic credits that was deposited into a demand deposit account. And out of that account, they wrote the check to the person you allegedly bought the property from. And here's the deal. The Modern Money Mechanics publication states that they were paid 9 times the amount in that demand deposit account. 9 times the amount. So how the hell can the bank be going under if they're getting paid 9 times for every time they sell a house? Yeah, I'm still, somebody needs to help me with that. So that money was actually the alleged loan, because there's no money. The alleged loan was actually created with your signature. And people tell me I'm crazy and all this shit. I tell them, look, I played football and I boxed, okay, in college. Those are 2 things that not smart people do. So I have to keep shit simple. And when attorneys give me shit on Facebook or get in my face, this is what I tell them. If there were like several owners of property, okay, before anybody could sign a lien against that property, all of the owners would have to be present to sign, right? Yep. Okay, so the fact that the bank accepted your signature on the lien against your property, on the mortgage lien against your property, the fact that the bank accepted your signature on the mortgage lien against your property proves that you own the property free and clear. Bam. Keep it simple. If you didn't own the property free and clear, they would have not only accepted your signature, and you would have to get some other motherfuckers to help you sign. You had to get some other people to help you sign. Think about it. Okay, time's up for thinking about that. You can think about that later. So the next one we're going to talk about, their mistake, is thinking the lender is the party foreclosing on your property. And I'm going to say this is a huge one, okay? Actually, I'm going to say this is probably the biggest one, okay? Because in the first one, thinking they made you a real loan, you can still defend your property, thinking that they made you a real loan, okay? But here's the deal: if you think the lender is the one foreclosing on you, you're screwed. Here's why: you'll be getting kicked out of court for failure to state a claim under Rule 12B. You'll be getting kicked out of court for failure to state a claim under Rule 12B because you do not have the party that actually started the foreclosure, the person that signed to start the foreclosure against your property. You don't have that person listed in your lawsuit anywhere. You got the lender, you got the servicer, none of those people sign your paperwork. None of those people sign the foreclosure documents against your house. Not a lender's signature or anybody from the bank, any damn where. The only people that sign the only signatures on the paperwork, on a petition or the notice of default letter is from the attorney. And they'll tell you, we're acting as a third-party debt collector. And they are. But what they don't tell you is that they're collecting for themselves. They're not collecting for the bank. They're collecting on their own behalf. And that's why we add them to the lawsuit as the number one defendant and their law firm second. And we do the law firm second to block anybody from the law firm from helping them. Yeah. And that creates a little bit of a problem for them because now they have to hire an outside attorney. And when the outside attorney finds out that you're kicking their ass for unlawfully foreclosing on you, acting as a third-party debt collector in violation of the Fair Debt Collection Act and FARA and the Administrative Procedures Act, they're not going to want to touch it. And I'll tell you why they're not going to help them. They're not going to help them because they're doing the same shit. Yeah, how they say, the cat's out of the bag. The cow's out of the barn. Yeah. So now the judge has to let them represent themselves in court because we all know that a pro se person, we all know that a corporation cannot represent themselves in court pro se. And they're going to have to let the attorneys represent not only the corporation, but themselves too, because nobody else will represent them. And that's one of the situations that we back the judge into and sue the judge for. And we build a record addressing this issue, okay? And then when the judge has to let them go through, you've already got on the record, wait, you objected, and here's the case law showing that the attorneys can't do that, and here's the court rule showing that, why is the judge doing it anyway? Because the judge already took their money and they don't want to give it back. And this is my opinion. My opinion is by the time they get around to the foreclosure process and the paperwork in court, that's just the last icing on the cake. They've already split the money up and done all the stuff that they want to do in the administrative side of things. And I'll tell you this, in the administrative side of things, if you'll look at the bottom of that lawsuit, the foreclosure documents that they served you, there's usually a stamp, a barcode stamping on there. And my opinion is that barcode stamping is a reference to the administrative file, the real file about how they're stealing your property. And I usually tell people to cut that out and then copy and paste it, cut it out, and then like copy a paper with that on there. Yeah. So then now this is the front page of your lawsuit showing that barcode on there. Yeah, that freaks them out real good because we're not supposed to know what that barcode is. And I actually figured this out working on the non-judicial process, because the non-judicial process, there's no court record theoretically. This is what they tell us. There's no court record until you get in the eviction process. Okay, but wait. They're all ready to sell your shit on the in 30 days. They're ready to sell your shit on the courthouse steps. So they got to have a file of your shit somewhere. That file didn't start in eviction court. Are you kidding me? I'm not buying that. Mm-hmm. The lender is not the foreclosing party. The foreclosing party is the third-party debt collector. That's the attorney. You check your paperwork, you'll find the attorney is the only person that signed your shit. The attorney is the only person. And I have people in the group that went to file their lawsuit, and the clerk wouldn't let this lady file her stuff because she had the attorney as the one offended. Now, this lady didn't read the instructional video like she should have. So she walked away thinking that she had shit for the documents. Yeah. And once they seen her face go down to, they just wrote her right down into the dirt. And then she found out later that the reason she had the attorney's name as an number one defendant is because the attorney is the only person that signed the foreclosure documents. The only person. And if she watched the instructional video, she would have learned that she is supposed to attach a file stamp copy of the foreclosure lawsuit the attorney filed to her lawsuit. And once she does that, now it's on the court record who signed to start the lawsuit. Because remember, I told you, you're going after the person who signed. You're suing the attorney. And when you get the right person on there, it's a problem. It's a problem. And a lot of times you can work this out by harassing the attorney before you go to court. I'd call them up. Hey, I need to see your foreign agent registration statement. You guys are supposed to have that shit on file for me to come. I like to come by and see that. And also, I would like to see the statute that you're using, because my legal team has informed me that the foreclosure statute is not a valid law. It does not contain the necessary elements to be considered a valid law. So you guys are taking my property illegally. I need to see these things before we go to court. This is the shit you should be telling attorneys on the phone, calling them up on the phone. And I'll tell you, people who do that, it goes a long ways. Okay, here's one. Trusting the attorneys to help you. Okay, the big mistake. Trusting the attorneys to help you. I'm not going to spend much time on this because everybody's figured this out. Everybody's figured out that the attorney is only going to help you and then throw you under the bus in the end. And I'm going to tell you why the attorney is not going to help you in foreclosure court. I'm going to just tell you why. I'm just going to tell you. The reason the attorney's not going to help you in foreclosure, well, the reason the attorney's not going to help you anyway. I'm just going to throw it out there, okay? Because I don't have a whole lot of respect for their asses, and I don't care. So the reason attorney's not going to help you is because they're not going to attack each other. What the hell am I talking about? Okay, remember at the top of the page, I told you the attorney is the only one that signed to come after you and steal your property. Only the attorney. Nobody from the bank signed it. So you got an attorney acting as a third-party debt collector, illegally foreclosing on you. Shit. Their buddy attorneys don't have to help you, because as soon as you hire them, they automatically get a cut of what they're going to steal from you, in addition to what they take out of your bank account while they're supposed to be helping you. So they don't have no incentive to do shit. They're already going to get a cut because you hired them. Anybody that think that's not the way things go, let me know, because that's the way I see them going. Attorney is not going to help you because their buddies are the ones that are screwing you. And when they get in the program, they automatically get a part of the screwing of you. And they get to take your money for pretending to help you. Now, this is a big mistake that most people make, especially because they get emotionally involved. They arguing the banking system. Okay. The only thing that I teach people to argue in foreclosure is the lack of jurisdiction. That's it. That's it. Okay. That's it. Because the whole system is fraud. It's fraud on fraud on fraud. So you can argue fraud all day long. At the end of the day, you still stink like shit. I'm just, I'm just saying. You can argue the fraud all day long. At the end of the day, you still stink like shit. So what you need to do is you need to start it from the gate. That's what I tell people. We need to start our program at the gate. At the gate, you're challenging the court's jurisdiction because they do not have an injured party. Okay, because the statute does not have the necessary elements to be considered a valid law. Okay, because if you have a copy of the jurisdictional challenge with an affidavit, there's 6 things missing off of that alleged contract that they filed in court. And those 6 things missing are what are part of what you agreed to with the lender when you signed. Okay, there's a lot. You see where I'm going here. Okay, and we never answer to their crap. We respond. You respond to what you need to kick their ass with. That's how we do it. We respond with your jurisdictional challenge with an affidavit, or you respond with your lawsuit against the judge. That's how you do it. And I could go on both of these lists. I'm going to have a video playlist for these obstacles because I could go on for like a long time, but I didn't, and talk about these things. But we won't try to get them all in one night. Okay, but the last one is thinking the judge is going to be fair. People tell me I think the judge is going to be fair, so I'm just going to go and like, oh my God, let me get out of your way. Judge is not going to be fair. The only way the judge is going to be fair is when you sue him or her and make them step the hell down and get the hell out of your way. That's the only way they're going to be fair, okay? Because it's not about fair. It's about taking your shit. And it's about them getting the money for taking your shit, getting the money put in their retirement account or all the other stuff that they do, the offshore stuff, all that stuff. That's what it's about. It's not about being fair. And, I listened to a couple other YouTube videos today. I want to see what other people are doing and how it compares to what I'm doing. And holy crap, I'll tell you, most of the people that are helping are not offering anybody anything in their YouTube video that can help them. Not a thing. They want you to do the same thing, forbearance or a loan modification or a bankruptcy. Oh, there's the short sale. None of those things are going to help you stay in your house. So if that shit don't help you stay in your house, to me, it's not an option. It's not a viable option if it's not going to help you stay in your house. And none of that stuff that all of those people, I spend 2 hours a day listening to people's videos and looking at, not one person offered any advice that would help people right now, that you can use right now. Not one. It's sad. And they all want you to do the same shit. One guy was saying, oh, well, as soon as you get behind, you need to call the lender and get the lender on the phone and let the lender know. I'm like, that is the biggest bullshit I've ever heard in my life, because I'm going to tell you why. Okay. I'm talking shit, but I'm going to tell you why. The lender don't give a shit about you. Okay. The lender use your phone call as a risk assessment. And as soon as you send them your information, your financial information, showing that you got more money going out than you got coming in, you're done. And now you just move your whole foreclosure shit up to the top of the list. Think about it. The lender went through some shit too when everybody was shut down. And everybody, yeah. So it ain't like their fat cats looking good and they don't need to steal your house. Oh, wait. So why should they work with you when they can take your property and resell the shit all over again? Oh, wait. So the lender already done a charge off And they also claimed it on their taxes. That's what a charge-off is. You claim it on your taxes, you claim it on your insurance. And then they sold it to a third-party debt collector. And then you paid them already for 15 years. And then the attorneys get to make money from you while they're stealing it back. And then I'm not quite sure how the bank ends up with it back again. But yeah, that's what happens, so they can sell it again for the 6th time. Yeah, sad. It's fraud. The bullshit needs to stop. And that's what we're working on now. So our end of the moratorium sale, all 3 of our main lawsuit packages are on sale now for the rest of this month. Well, for $299. Well, one is at $300 because I forgot to change it. So I think you'll be all right with that $1 extra. Okay, so they're still marked down from $550 to $299. And I've increased what you're going to get in the package. So you will get all of the documents that you need to smash any state court process that's going on. You'll get the documents that you need to sue the judge with, to move for reconsideration. All of that is included in the package. And if you click on the link that I put in there and scroll down to the bottom of the page, then you'll see a little bit of write-up about the documents. And I also have a couple of videos in the offer, also the instructional videos showing you how to use documents and how to personalize them and all of that stuff. So if you can follow the instructions, you can do this. And I also have coaching on our private Facebook page. Now we have almost 600 members in our page, so I closed the page now. Now you can only join the page if you invest in one of our lawsuit packages, because it's a study group. And I want to be able to communicate with people that are using the packages and get the real-time feedback so that I can make changes, see what's going on, let other members know what's going on over here so they can look out for the same thing. And that's kind of what we've used this group to build what we have going right now. And it's pretty cool what we have going right now, because we're starting to get a few, well, we had a few wins where the attorneys went and sat down. I call them a win, you call it whatever you want, but we're starting to get a few wins now where the judges had to give up and go sit down because it was too much fire. Now, if you're broke and you're facing foreclosure, I'm going to show you the best deal that we have on the table for you. If you're broke and facing foreclosure, this deal is $50. And I put this together for a couple of reasons. And let me find, okay, here it is. So this is a motion for a change of venue. Now, a change of venue, you can move for a change of venue in the interest of justice. Any party can move for a change of venue in the interest of justice. So what we've done with this is we set this up to where you will be able to remove the attorney's lawsuit from state court and move it over to federal court and just screw them all up. Because you can file federal case law in state court, but you can't file state case law in federal court. Don't go that way. But here's the deal. You're moving it because the attorney is the only person that signed the foreclosure, and the attorney is considered a foreign agent. And a foreign agent must file anything, any claim in federal court. If you are suing someone in another state, you can't sue them in state court. You have to sue them in federal court. If you're from another country, you have to sue them in federal court. And the fact that the attorney is violating the Fair Debt Collection Act practice by misleading themselves as a debt collector when they have no consideration in the deal. And that's what this change of venue motion is about. It's pretty badass. And you could actually take the change of venue motion and you could use the information in it to make a motion to dismiss or a motion for summary judgment. In my program, the sky's the limit. If you limit yourself, and I see it, you're going to be on the bench. So $50. This thing is on sale for $50. And I was about to use it for Shamel, and she got her lawsuit filed against the judge. So we're going to wait and see how that works before we move her stuff over. If they don't do the right thing and let her dad back in his house, next week we're going to use that motion for a change of venue. But I have it posted. So if you're struggling with $50, now this change of venue, you know, it's not a lawsuit where you get paid a whole bunch of money or whatever. All you're doing is forcing them to move their shit over to federal court because it shouldn't be in state court. Because state court don't have jurisdiction to hear that shit that was filed by a foreign agent. Foreign agents have to file in federal court. So I think this document could smash the whole case. For $50, okay? It's 50 freaking bucks. And you know, the sad thing is, I don't think anybody's used it yet. Which is kind of sad, but that's all right. I can't make you drink. I can only lead you to the water. Okay, so D Bush, man, I already told you guys what you need to do, so I'll be repeating myself, and I hate to do that. You should go to, hopefully you're already on my YouTube channel, and you should go to you should search jurisdictional challenge with an affidavit update and watch that video, because I updated it, letting people know how the attorneys are trying to get out of this situation. And yeah, you can challenge jurisdiction up to 15 years, man. You know, Tina said something about the case was closed. No, the case ain't never closed. The case is only closed if you listen to their shit. And you need to remember that the best way to tell when a bar member or the clerk or the court or the judge, the best way to tell when a bar member is lying is to check and see if their mouth's moving. Because if their mouth's moving, they're lying. Okay, let's see where we're at here. I think we're almost to the end. So the moratorium is going to come to an end at some point. And when it does, will you be one of the homeowners getting your foreclosure terminated because you're a pain in their ass sucking up their time when they have so many other people that's giving up? And you're in the way of stopping them from getting 5, 6, 7, 8 more foreclosures because you're dragging their asses in court, making them answer to your stuff on your lawsuit over here, addressing some other stuff. Will you be that person, or will you be one of the folks calling me in a panic, offering to pay me to do this for you to stop the eviction? And just to make sure that we're all on the same page, I don't do that. So if you call me and ask me for that, you're wasting your phone call with me, because I don't do that. I don't rush around in a panic. I don't run around like a crazy person. And the way I see it, if you're not smart enough to invest in the program, if you're in the program, or you have, or you're aware of the program and you're not smart enough to invest in it before they're ready to kick you off the property, I don't think that I'm the coach for you. Now is the time to take action, and the price is affordable. So you guys need to click on the link and get started. You cannot let the fear dictate your fate. Thank you, Dalen Shay. I'm going to keep up the good work, because this is my retirement program, so I have to make it work. So you guys, I want to remind you please take the time to click on the ads. I know they're a pain in the ass. I had one lady ask me if I can move the ads over to one side. No, I don't have shit to do with the ads, except I'm happy to see them on my site, because I get paid when you guys click on the ads. And when I get to the point where I'm making a little bit of money, then I can reduce my prices even more. My goal is to put myself in a position to help anybody that's facing foreclosure. Okay. I would like to not be turning anyone away. Okay. I would like to have a program set up to where I can help anybody that's willing to fight. And that's not going to happen until I started making some money on the YouTube thing. So I need you guys to click on those ads. Please subscribe. Click the like button. I think there was 13 or 14 people here tonight. I should have all those likes. If you respect what I'm doing, take the time to click that like button and make sure you ring the bell so that you can be notified when it's time, when class starts. And leave a comment. Leave a comment. Great job or whatever, because that lets YouTube know that what I'm doing is fire and you guys are, and I'm bringing value to the table. So when they see the comments, that lets them know. And also, please, you guys, the offers that I put on here, those links to my offers, share them on your Facebook page. Okay. I got the attorneys from California. They got Facebook blocking me from advertising on their platform. So that's all right. I can figure out a way to get my shit out there. So you guys share my stuff on your Facebook page and have your friends share it too. So that way people who are need help can see they have options and don't have to take shit from attorneys, and they don't have to hire attorneys help them. And I'm going to leave a link to these things in the comment section too, for the people that come in new, so they don't have to go to the feed to get them. So I will try to be back on here next Tuesday or Wednesday. And I'm not sure what I'm going to talk about, but I'm sure it's going to be fire. So thank you guys for hanging tonight. I hope I've said something that's going to help you guys out. And I got a $50 deal. If you're facing foreclosure, I got a $50 deal that can help you get that shit out of your face. All you got to do is step up to the plate and get it and get going with it. Remember, we ain't living in the fear, okay? We ain't living in it. We ain't got time. We ain't got time to live in fear.